Hi, everybody. This is Elektra Yao, artist visa lawyer with offices in New York and New Jersey. I'm here today to talk to you about artist visas and what type of work can you actually do on your visa. This is actually a pretty complicated question because everything goes back to the original petition and how it was filed, what the field of endeavor was used within the petition, what types of contracts were used, what was the professional title. Everything harkens back to the original petition and how all of that was architected, which is extremely important to realize that when you're developing your artist visa petition, you need to be strategic at every point in the petition, including the beginning where you're starting to identify your field of endeavor. So your field of endeavor is basically what field you work in, what is your profession, identifying the professional title that's going to be used, and identifying what type of work you want to do. Sometimes you can't add certain types of work if it was not already identified within the petition in terms of a future work contract. So let's just start at the very beginning. Let's talk about that original petition that's filed. So you file your petition, and within your petition, you've identified yourself to be a filmmaker. So you've identified what the field of filmmaking is, and you have contracts that talk about what you're going to be doing as a filmmaker. I chose a pretty ambiguous profession just to illustrate my point, because I personally have worked with filmmakers that do more than just directing. They will do editing, they will do sometimes gaffing on their work. They will sometimes do producing. So filmmaking is kind of a very multifaceted profession that is not necessarily limited to directing. And in my experience, most people don't only want to direct, and for various reasons. They don't want to limit their income. They want to diversify their income. They want to be able to work on different types of projects. And also, they want to be able to accept work so that they have a really strong body of achievements for when they choose to apply for the artist green card. So, as I said, you're a filmmaker, you filed with three film contracts. In these three film contracts, probably you've identified that you're going to be directing. Well, you get approved and you decide that you want to teach. You get an offer from NYU, you want to teach at film school. Can you do that? If you were not identified as a teaching artist and you did not include a teaching artist contract, many attorneys would argue that you would not be able to accept that future employment. Or let's say you are an editor, right? Part of your filmmaking is you also edit, but editing was not discussed anywhere within the petition. You most likely will not be able to accept that contract because it would be considered outside of the scope of the petition that was originally filed, which is why I will say it harkens back always to the original petition that was filed. Now, if you want to include those additional jobs, then you might need to file an amendment, just because maybe those new job offers might materially alter the underlying petition that was submitted. So, what type of work can you actually do? Again, let's go back to the beginning. If you have identified your field of work as editing, gaffing, directing, producing within the scope of the petition, you've got also the accompanying labor consultation letters, letters of no objection from the various unions, right? Authorizing you or confirming that they don't object to you getting the O1 visa. And you have the contracts to support it. And all of those achievements have been discussed within the letters of recommendation. Then, yes, if you're filed as a teaching artist slash filmmaker and your filmmaking contracts discussed gaffing, editing, producing, etc., then yes, you can add additional performances and engagements once you are approved. That is probably the most comprehensive explanation. You want to make sure that your underlying petition authorizes you to do the additional work that you want to do. Otherwise, a couple of things would happen. Number one, if you end up getting a job at a large company or a large agency, part of the recruitment process is going to be to ask you for what your underlying petition is and what it looks like. They want to see the approval. They want to also see how your case was argued to make sure that you can actually accept that employment and they can extend that offer to you. Number two, if that petition is not satisfactory to the company, i.e., this field of endeavor has not been properly identified, the scope of work has not been identified, you don't have the relevant labor consultations, then most likely you will not be offered that job, and that employment will not materialize. Even though you can add material engagements to your petition after your approval, if you don't have the proper authorization, i.e., if you don't have the underlying contracts, and if you don't have the labor consultations, and if this wasn't identified in your professional scope of employment, then you won't be able to accept it. It's really, really, really important to make sure that you really understand the strategy of your petition, the strategy of how you want to engage within the next 3 years. It's a very difficult question to answer. I'll be honest with you. A lot of people, even in real life, who aren't undergoing the artist visa petition, don't really know what they want to do in the next 3 years. They can't really anticipate the future work that they're going to do. But different from the H-1B visa, different from the E-1 visa, different from the H-1B1 visa, the O-1 visa allows for additional employment after you've been approved, which means that you're not stuck with the contracts that you included within your initial petition. Congress has allowed for these changes because Congress has recognized that the arts fields, the creative fields, are volatile fields. Things change all the time. Projects lose funding. Major players drop out. Sometimes artists get better offers. Sometimes artists get fired. This is all a part of the industry norms that are not so much apparent in traditional 9 to 5 employment. So, in traditional 9 to 5 employment, you might have a project that you're working on, but for example, if that project doesn't pan through, that doesn't mean that you lose employment or that you lose your job in many, many cases. Of course, there are always exceptions, there are always things that change, but in general, Congress has identified 9 to 5 work as being more stable work, and O1 work as being work that can change because those are what the industry norms are for the majority of the creative fields. Now, this doesn't mean that you can't use your O1 visa like an H1B. You could definitely use your O1 visa and just be with one employer. You can utilize it as an H1B. I don't really recommend that strategy unless you really don't have a lot of future employment, just because you're really exerting a lot of energy, a lot of force, a lot of legal work to just work with one employer. If you had gotten accepted into the lottery, then you could use the H1B for that purpose. But many people do use the O1 to be able to just work with one employer, with one job. Now, who can you work for? Are you limited to a company on an O1? Are you limited to just a production? No, with the O1 visa, you can work on all different types of projects on behalf of companies, on behalf of one ended projects, on behalf of private individuals. All of that sort of employment is permissible by law, is allowed for you to do. So, your underlying petition could look something like this. You can have a future teaching artist job where you are teaching a class, for example, at the Artist Students League, for example. You can be giving private lessons, and you can also be working for a production company. All of that is permissible simultaneously during on for the O1 petition. And if the contract that you include in your petition for teaching artists maybe doesn't pan out, you can add additional performances and engagements to your petition once you are approved. So, what type of work can you do? You can work for companies, you can work for private individuals, you can work on behalf of short term projects. All of that is permissible by law. Can you add additional performances and engagements to your petition? Yes, for the O1B visa, you can add additional performances and engagements to your petition. This is different from the O1A visa, where the itinerary that is submitted within the petition is the itinerary that will be utilized during the O1 validity period. Um, now, can you change the field of endeavor after you've been approved? No. So if you file your petition with, 2 contracts to work on a project and one contract to work for a private individual, Can you then add a teaching project or a teaching contract to your petition? The answer is no, you can't do that. You need to stay within the field of endeavor that was identified with the professional title that was utilized, which is why this is extremely important. You have to be very strategic at the beginning of representation, at the beginning of how you're going to draft and how you're going to architect your O1 visa. Extremely important. So just to recap, what type of work can you do on your O1? The O1 is a special visa because it allows for diverse types of employment, not necessarily and not exclusively 9 to 5 traditional employment. On the O1B visa, you can work on behalf of private individuals. You can teach, you can work on projects, long-term projects, short-term projects, projects that may last only a day. And you can also have full-time employment on your O1 visa. Now, can you change the field of endeavor after you've been approved? The answer is no. You cannot add a teaching artist contract after you've been approved if you did not include an original teaching artist contract in your original petition. Now, let's discuss something a little bit more complex. Let's discuss full-time work versus part-time work. Can you include multiple part-time projects on your O1? Yes, absolutely. Can you include full-time projects on your O1? Yes, absolutely. Can you add a full-time job if your original petition only included part-time work? The answer is most likely no. There is no set answer for this because the law has not really identified this. This is kind of a gray area in the law, which follows under material change to the petition. I feel like arguments can be made both ways. Yes, full-time work can materially alter the petition. Yes, no, full-time work doesn't materially alter the petition. I feel like it can go both ways. But in the essence of being conservative so that you want to preserve full-time employment without having to do to argue with USCIS. If you want to preserve your ability to work full-time, you should absolutely include full-time petition or full-time contract within the underlying petition. That is going to preserve your ability to work full-time. But sometimes you don't want to work full-time, and that's perfectly permissible. You can have multiple part-time contracts on your O1 validity period, just like you can have a full-time contract, just like you can have a mix. You can have a full-time job, and then you can have multiple part-time contracts for work that you do on the weekends. All of that is permissible. All of that flexibility is allowed under the O1. It allows you to really, really strategize your time, really, really accept projects that can improve your professional profile and allow you to be strategic and tactful in terms of developing your profile for an eventual EB1A artist green card. So this was all very, very nuanced and very, very complex. I just want to share that today someone sent me a denial notice that they received filing with another law firm. And in that denial notice, one of the most salient parts that USCIS discussed was the contracts. So if a contract is not properly drafted, this is something that is going to either prevent you from getting approved or severely limit you when you are approved in terms of the type of work that you can do. So really make sure that you're working with an experienced O1 lawyer, an experienced lawyer that has knowledge of the arts, knowledge of the O1B regulations and how it pertains to artists, so that not only can you use your time to really maximize your potential, your professional potential on your O1, but make sure that all of those nuances are explored so that you can make the most out of your time and file an O1 petition that is best representative of how you want to navigate your O1 validity period. So thank you so much, everyone, for watching on Facebook and on Instagram. I will be back tomorrow to kind of discuss the importance of a marketing plan, how a marketing plan for artists is vital, how you need a marketing plan to be able to understand your future work, understand how you want to structure yourself as a business, understand how you want to grow as an artist. Growth as an artist is not something that just happens overnight. You need to plan for it. You need to create opportunities opportunities for yourself. And most importantly, you need to be consistent. Whether you're an artist seeking out an O1 visa or an artist that is trying to trademark her brand name, her artist name, her company, a marketing plan is vital for your growth. Thank you all for watching, and I will see you tomorrow.